In Washington state, a divorce typically takes about 1 year on average. It is at least a 90-day process. Once the petition for a divorce has been filed and served on the other spouse, then the 90-day waiting period starts count. And only until those 90 days have passed and you have resolved all of the issues that need to be resolved in a divorce, like asset and debt division, parenting plan, child support and spousal support, and tax considerations. And if all those issues are resolved, then you can go to the court on the 91st day after the petition was filed and served to get the divorce finalized. But that's not typical. Most divorces are going to take about 1 year to complete in Washington state. So the steps that are involved in getting a divorce in Washington include filing a petition to ask the court for a divorce to be entered. And that is a simple document, but there are a number of considerations to take when you're deciding how you're going to fill it out, whether to ask for certain provisions to be ordered right away or directly, or whether to keep it more open-ended. And those are really good discussions to have with your attorney to be strategic and think it through instead of just firing off a document that you've downloaded from the internet. Once you've filed the petition for divorce, then it needs to be served on the other spouse. And sometimes serving means that we hire a process server to have it formally delivered and handed to the other spouse. Sometimes it means having a conversation with your spouse about accepting service of process so that they don't have to be hijacked at work or in some other public place and be embarrassed having a process server hunt them down. And we can negotiate the delivery of the divorce petition that needs to happen to get the process underway to have a divorce in Washington state. This is a strategic decision, and it's really important to discuss it with your attorney because there are implications and some pros and cons to doing it both ways, but you want to make sure you've thought through those issues. Once the divorce has been served on the other party, then we can typically move towards negotiating the terms of what is going to be awarded on a temporary basis, meaning who gets to live in the house, who's going to pay what bill, how are the children going to be cared for while the divorce is pending. Everything that goes into your everyday life needs to have some sort of determination. Sometimes spouses can do this informally and cooperatively. Other times they need to go to court and get a temporary order from a judge determining who is going to pay what and do what by when it comes to all the ordinary things that happen in life. And we abide by those terms. And in the meantime, we negotiate, we do discovery. Discovery is the process of gathering information, gathering documents, materials, data to determine what exists between the parties, what is the asset makeup of the parties who are getting divorced, what debts do they have, what property do they have, and how much is it valued at. We need to gather all that information because all of the information gets to come before the court. It must be exchanged. There are no secrets when it comes to the assets and the debts and what the positions of the parties are, what they want to walk away with. Sometimes they don't know right away what they want to exit with from the divorce. And so that's an important conversation to have with an experienced family law attorney because they'll give you some perspective. They've done this before. They can tell you what is more likely to be an achievable goal when it comes to the asset and debt division and the parenting arrangements. Once we've gathered all the information through discovery, we typically start working on final settlement negotiations. And that may look like exchange of documents and proposals between attorneys. It may also include going to mediation or arbitration to get a facilitated discussion happening on the same day in the same place so the parties can make some final decisions and reach a settlement when it comes to all the terms that are involved in their divorce. Most divorce cases in Washington resolve with a settlement agreement, often a mediation. Only about 10% of divorces are resolved via a trial. But if you're not able to come to a total agreement, or there's a few issues that still need to be resolved because you couldn't reach an agreement with your spouse, Then the final step is to go to trial and present evidence to a judge, not a jury, and let the judge decide what is going to be the final outcome of the asset division, the child custody, and support arrangements. If the trial result is not favorable, you still have a right to appeal and to ask for a higher court to make a review of the decision that the trial court made. The very final step in the divorce process for a few people is an appeal. If you go to trial and you're unhappy with the result that the judge has ordered in your case, then you do have a right to an appeal of your divorce, but it is a very short window, only 30 days from the time that you get your divorce order to make an appeal to a higher court. The documents that you need for court when you're going through a divorce include a petition to get the case started, and then there's going to need to be a bunch of disclosures when it comes to particularly your finances. In Washington State, we do something called a financial declaration. And it is essentially your budget or your prospective budget as to what you expect your expenses are going to be once you're living separately on a reasonable estimate, along with a breakdown of all of your individual debt payments that you need to pay every month, your credit card, your car loan, your mortgage payment, and the financial source documents that prove all of those numbers. So you're going to have to provide bank statements, loan statements, statements proving what your retirement values are, what your contributions are to your retirement and your brokerage accounts. All of your financial data does need to be gathered, provided to your attorney so that they know what we're dealing with and they can advise you on how this is likely to play out and what your options are when it comes to the breakdown of your assets and your debt, and how the bills are going to get paid in the meantime. There can be disputes while the divorce is pending about who's going to pay what bill, who's going to pay the mortgage, the car loans, tuition payments for college-age children, or private school payments. All of those things can be negotiated, but we will need the data. Mediation is a structured negotiation process that can help divorcing parties come to a resolution in a way that gives them a great deal of control over the outcome and acknowledges their positions and gives them an opportunity to avoid trial, avoid a decision in a public court that they have very little control over. Mediation is a great tool for people who are going through a divorce because it is compassionate and it's a way that they can end their marriage as much as possible on their own terms. When you're not able to settle divorce through mediation or negotiation, that means you have to go to trial. And when you go to trial, you're rolling the dice, you're presenting your whole life in just a few hours to a few days to a stranger in a robe who has really no relationship with you, has very little time to make a decision over major decisions that are going to impact your life for the rest of your years. Mediation is a great opportunity to resolve your divorce and to move on with your life in peace. If you have any questions about what to expect in Washington Divorce Court, just give us a call at Viewridge Law.